To all of you, we just have listed this matter because we could not deliver the judgment within time.
My lord.
So therefore, we need about 3 weeks more time to
Very well.
compile our, to
Very well.
get it our judgment. Because of the guidelines now that within 90 days it has to be delivered,
Very well.
it has been listed today. We need 3 more weeks.
Very well.
This is only listed only for that purpose.
And if any clarification is required by a
No,
lordship
it's,
also?
clarification not required. Your
Not required.
arguments are extensive.
Very well.
It is only because of that we have
No
been
required.
compelled to
It is the call.
consider everything, and it's taking us some time.
Even for us, we read it and we forget it. That is our fate. Very well.
We are sorry that it couldn't be.
No, my lord, it is perfectly, my lord is doing so much work on it. We appreciate whatever. Good. Obliged.
It will be listed with
Obliged.
3 weeks. I will propose to complete it.
Obliged. I have a matter in the afternoon also. So anyway, I had to come.
Just record the presence. Mr. S. Mr. K. N. Balgopal, Learned Advocate General for the state, as stated by Mr. M. K. Shi, Learned Additional Advocate General. Mr. S. Datta, Mr. A. Datta, Senior
Mr.
Counsel,
Dasgupta.
along with Mr. S. Datta, Learned Senior Counsel, assisted by Mr. Mr. S. Datta, Learned Counsel for the private respondent.
Well,
And Mr. K. Kalita, Learned Standing Counsel for the all respondent number 8. Huh? Acha. And Mr. Vivek Puri, Learned Mr. Vivek Puri, Senior Counsel, who's preparing video conferencing, is present along with Mr. K. Kalita, Learned Counsel for respondent number 8. As the order could not be delivered, the matter has been listed. Today,
Manoj, I'm so sorry for being a little late, Manoj. My apologies.
it's okay. We are just listening it because we couldn't deliver the order in time.
Manoj.
We need
Oh, that 3 months period, Manoj. Yes.
3 more weeks we require.
Okay.
oh,
So the clarificatory hearing is concluded. Order reserved.
Grateful, Manoj.
No, in fact, we are sorry. Though you are
Oh.
great, we are sorry that
Manoj, for the amount of time we took arguing, I don't think any one of us is complaining about that.
May I, your lordship? Lordship, I'll be giving the list of the council like applicability.
very good. Very good.
Great.
That will settle your lordship for the. Only aluminum. part, your lordship.
Alimony part, lordship. That
On your prayer.
we are issuing. I mean, 1612 order speaks that it was a prayer from the additional PP.
by Lord. Oh, I had to take that.
Maybe.
In one of these matters,
But-
bench in which I was also a quorum,
Yes,
we had passed an order.
my Lord.
You have a copy of that order.
Perhaps one of the issue was not examined, madam, but it was there, madam. It was raised. In fact, Mr. Ahmed was arguing in that case.
Is that I have no copy, but your lordship disposed of in this issue.
I think in any case, this obviously the offenses are different. So in any case, both the matters will have to be heard separately, even if it's tag also.
No, the issue is only one. That's why we remember, because I had the occasion to deal with it.
My lord.
But I think I dealt with it about 1.5, 2 years back.
Yes, my lord.
Yes, yes. So I vividly recall having touched this issue, but I am not actually aware of what the order was. Yes, yes.
I mean, we can take the report.
No, not in this case.
No,
only different.
on different case.
Not in this case.
Oh, my lord. My lord.
In another case, I passed some order because this issue was
Yes, sir.
taken up.
My lord.
Your lordship does not, your lordship done on merit. In this, your lordship, in this case, your lordship done on merit. No, that's why I don't recollect. I have touched the issue, I know. Yes. But what is the result of that? I don't remember. Try to find it out.
My lord.
Yes, yes. Take it up next week. In the meantime, you find it out.
My lord.
Both sides are represented. The this is item 7, huh? Item 7, this order will be in the appeal, not in IA. The learned counsel for the petitioner has, for the appellant has submitted that by an order dated 16/12/2024, this matter was tagged along with criminal appeal 252 of 2022 as both the cases along with other cases were tried by the learned special judge Chirang in the absence of the public prosecutor. And it is for that limited issue that both matters are tagged together. However, it is submitted that on facts, the two cases are separate, and would be and maybe separately heard. Next para. How much time would you need to search the records and to find out whether what has happened in between?
My lord. My lord, I could not. Check it.
You see, you will be having the records to tell us
Yes, my
how this bench or any other bench has dealt with the issue.
My
Because you'll have I think in your diary, you will find it out. From Chirang, there were about 12 cases. We had caused an inquiry, more than 12 cases were tried in this manner.
my lord.
But I have a very faint memory. I can't say exactly how many cases, but I have a faint memory that
My lord.
in this matter it was done. So the issue came as to whether the special judge has acted as a prosecutor and as a judge. That was the issue involved. It is because of that I vaguely remember. Otherwise, I would not have remembered it.
But here we have one letter in our file, my lord, draft letter perhaps from LR to the public prosecutor of Chirang, my lord.
After that, it was appointed.
My lord.
When we took a serious note about that,
My lord.
then they were appointed. Because on our administrative side, I took up the matter with the then Honorable Chief Justice.
My lord.
He informed the When,
My lord, any date after next week, my lord, next week, I'll
the 7th of January 2025.
right.
Accordingly, on the clear made by the APP, sometime is granted to verify as to what is opinion in similar matters. If it is possible to retrieve information from the records. Next, the list on 7-1.
For now, they
For
item eight.
you just say both sides, including Ms. L. Devi Lanet. You are legally counsel, will respond to our petition, in first time. And in the second case, they say in view of the order passed in item 7, influence, list this matter on 7/1/2026.
Deeply obliged.
Item 10, 11, 12, 13.
Lordship, matters that come out for hearing your lordship. But the lordship, there's an IA, this one there. In item number 10, your lordship. If your lordship takes up the hearing, I have no objection. But if they place for IA, we could not file our affidavit, my lord.
So you have to
Objection.
wait, because you see it's mandatory. Mr.
My lord,
Ahmed will always
with all
tell-
respect, I would submit before your lordships that except these accused persons involved in the appeal, 3 appeals, my lord, they were all released on bail, my lord.
On the ground of juvenile, your
On
lordship.
on the ground of Amarar, on the ground of juvenile,
Because Supreme Court has said that even juvenile has to be released.
And one person on.
and
for
earlier
age.
release, my lord, earlier. Recently, my lord, Pratap Pal, Porimal Pal, Porimal Pal were released on bail, my lord. All the accused persons except this appellant is in jail, my lord. Since the date of judgment, my lord,
We understand.
about 10 years, above 10 years, he has been detained in jail continuously, my lord. So, my lord, if appeal is not heard today, then, my lord, he may be released on bail at least for some days till hearing of the appeal, my lord.
You file it by Wednesday.
By Wednesday, yes,
We
Right.
are fixing it on Wednesday.
lordship,
Otherwise, we'll consider the
lordship.
Wednesday.
Wednesday, thank you.
My lord, what is necessity of the affidavit?
89 says so.
The requirement of-
My lord,
Yes,
have
yes.
to-
My lord,
We have to. do-
say, by way of affidavit, she may file a objection, my lord, bail objection.
That's what is- that's-
Bail objection.
You see,
What
I
is
come
the
from
bail
the,
objection after 10 years, my lord?
I
What is
come
that?
from the civil
Other
side. So
person-
every time I use the word affidavits,
Yes,
but it is an objection.
my lord, orally she may raise
No,
some
no, that's
objection, my lord.
requirement of.
Or,
It's a mandatory
on the
requirement.
other hand, my lord, my respectful submission, in view of the fact that all the accused appellants in this case, say 5-7 accused appellants is released on bail, my lord.
No, we
These
understand.
persons,
We understand. We are not saying
This
that
person
your
is-
prayer is incorrect. Mr. Ahmed, your prayer is right, and you are rightfully pressing it.
oh, my lord, with
We
certain,
appreciate that, but you see that the requirement, unless we do it,
at least till hearing of the appeal,
those
my lord.
orders would be questioned.
So maybe submitted orally, my lord.
Right.
Hmm.
Wednesday.
Wednesday. Fixed date.
Wednesday is 26th.
What is that?
All sides are duly represented. The Mr. N. Ahmed, learned counsel for the applicant, has pressed the bill for bail on the ground that the applicant has been in judicial custody for more than 10 years. Since you are arrested on the date of judgment,
Yes, my lord.
about 10 years, having been arrested immediately after the judgment was pronounced. The next P. Bhuyan, runner APP, former senior counsel assisted by
Jason.
J. Saikia, runner counsel, praised for granted one last opportunity to file an application by the next date of listing, next para. It is made clear that in view of the projection that the applicant has remained in custody for almost 10 years, matter of the security application shall be taken up for consideration on the next date of listing. List on 26/11/2025.
26/11.
26/11/2025.
Lord.
And in the appeal, you write separately. Mr. N. Ahmed, learned counsel for the appellant in Criminal Appeal 78 of 2016. Mr. S. C. Biswas, learned counsel for the appellant in Criminal Appeal 94 of 2016. And Mr. P. Kotaki, learned counsel for the appellant in Criminal Appeal 50 of 2017 are present. This matters on 26/11/2025. Along with IA Criminal 1154 of 2025.
Time being item 3 for hearing.
Your lordship, in this matter, actually, the matter settlement process is going on, lordship. So mediation may be given in the month of January.
No. You see, first part we can't agree that mediation process, your settlement process is going on.
Yes, your lordship.
Because if
Pronouncement of judgment, item 1. PIL 18/25.
this PIL is dismissed at the motion stage by imposing a cost of rupees 10,000 on the petitioner to be paid to the Itanagar Municipal Corporation within a period of 1 month upon recovery, the amount shall be kept in a fund to be utilized for disaster management purposes.